welcome everybody to the Dope CFO podcast. I am back, haven't been back in a long time, but I am super excited with this episode because there is a lot, as we all know, going on in the cannabis and hemp world. We are almost to December of 2025, and we got a year to the midterms, and there's a lot of stuff going on as well. I've got Rachel Gillette and Jen Benda from Holland Hart. I consider you two in the leading, if not the leading, tax attorneys in the cannabis and hemp space for many, many years. You all are participate on the AICPA Cannabis Conference and other AICPA conferences as well, including writing your newsletter. We'll get to all where we can find you in that later in the show as well. So I'm super excited to have you on and welcome both of you. And I'll maybe start off before we even get to questions. Do you want to each just introduce yourselves in case I blew something?
Absolutely. Thanks, Andrew. I'm Jen Benda. I'm a tax partner at Holland Hart. I've been representing cannabis companies in IRS exams for at least 10 years.
Hi, thanks for having us, Andrew. I'm Rachel Gillette. I'm partner and leader of the cannabis industry group here at Holland Hart. I work very closely with Jen on tax matters, and I've been representing cannabis businesses since 2010 in both regulatory, tax, and corporate matters.
Awesome. Well, welcome aboard. I added, so originally earlier in the week, we were, or last week, inviting you on to talk about some cases, which I want to do. But in the interim, our government reopened. And as our government officials are like to do, they slip in little things that nobody cares about, like hemp and cannabis into a bill. And it finally starting to hit the mainstream news, but it wasn't even, it was so small of an issue to the main industry that they don't care. But this will lead into many topics of the day because I have a big community of followers. We talked about this a little earlier, where people just say, "Oh, this is this or this is that." But in everything from these cases to the government shutdown, there's just so much nuance, and one thing gets slipped in a bill here, pulled out of a bill later. And so if we look at this, so for many years, when hemp was legalized in 2018, they kind of got a free pass. And really, I think back then everyone thought, oh yeah, CBD doesn't get you high. Let's just legalize it. The chemistry experts figured out, oh, wait a minute, we can get very high from these different THC derivatives out of hemp. And so basically what happened is we got a $30 billion hemp industry over the last 7 years with a lot of intoxicating THC. So THC is THC in my brain. That is a chemical that gets us high if we want it to, from both the cannabis plant, the hemp plant. And I always go back to what population want? We're divided 50-50 on 1,000 topics under the sun, but it turns out with THC, the majority of Americans, even in illegal states like Texas, want access to these products. They don't care how they get it, and they don't care about the laws and regulations. They just want access to these products. But then on the industry side, like you said earlier, a lot of cannabis companies, rightly so, are complaining this isn't fair. We're getting subject to 280E. They're selling stuff across state lines. They've got all these benefits. There's also the illegal market issues. Now the hemp was now illegalized, or at least these THC products under the new government shutdown bill. Let me just dive in with Rachel. Do you want to start on where do we go from here? I know it doesn't take effect for a whole year, so a lot can happen in a year as well.
Yeah, so the big news of late is that in the bill to reopen the government, there was this language slipped in that closed the so-called hemp loophole, which sort of, the whole hemp industry developing sort of illustrates that cannabis really should be legalized all over the United States. And I think this is a failure of the federal government to really end prohibition of cannabis, because you see a significant amount of demand, and you also see, as you say, consumers want legal access to products that are intoxicating. And so this whole industry sort of developed as a result of hemp being federally legal and derivative products of hemp being legal. And so they've closed the so-called loophole. And what developed in this industry, obviously, is an industry that was largely unregulated. And so, and then you see a lot of demand in states where cannabis isn't otherwise legal or there isn't a licensing system. Um, so so they've now the federal government has said, okay, you've got to stop selling any products that exceed more than 4.4 THC in total, which would be most of the popular hemp products that we know of today. Those can no longer be sold after 1 year. So this is going to have a tremendous impact, obviously, on the hemp industry. But I think you're correct that, people who have been operating within the legal cannabis industry in states like Colorado and other states where there's a strict sort of regulatory regime and a lot of costs associated with operating a marijuana business have sort of observed that, there isn't necessarily a level playing field there. And the true answer is, look, it's never a good thing when we're going back to prohibition, right? We're
Yeah.
prohibiting cannabis when we've taken all these steps to end prohibition. So, we've sort of got to figure this out as advocates of cannabis, I think, or the legalization of cannabis or the safe adult use of cannabis. So, what's going to happen in the next year, I'm not sure. I mean, I think there's potentially an opportunity for there to be federal legislation within that year that could better clarify maybe the legal status of cannabis. I mean, obviously, we're in the process of rescheduling cannabis to Schedule 3. So, but it
Can
really just continues to illustrate how prohibition
yeah,
has been a failure.
failure.
There's a
Can I ask
tremendous demand for this.
a quick
Yeah,
side question on the state side? So
sure.
just like marijuana is federally illegal and marijuana THC, but states came in and said, well, tough, we're going to legalize anyway. Can they not do the same thing on the hemp side if they want to at the state level?
Well,
So
they have, and in fact, that's been a trend that's developed over the last few years because
shut my
there's been sort of a lot of folks that have gone into states that have legal licensing of cannabis and they've been selling products that are intoxicating in those states. So a number of states have actually already passed regulations and laws that maybe prohibit certain types of hemp products, Colorado being one of those states. So there was already a trend towards restricting these products in some way, or certain products, hemp products in some way, but not in every state. And where you see a large proliferation of these products and them being sold in gas stations is states like Texas, where
Texas.
cannabis isn't otherwise legal. So,
And I wonder if Texas, because I have seen those states coming in and restricting, but I wonder if a state like Texas, if enough people there complain, are going to say, well, we're not going to legalize cannabis, but we're going to legalize hemp. Who knows what's going to happen, but it'll be interesting to see. But I guess the bottom line is we don't know what for is going to happen for a year. We do know the midterms are coming right up, I mean, before actually this law expires, and so I think this will be a big lobby issue, and even power people like Target and beer companies, and there's a lot of mainstream legal companies that have been incorporating this quote legal THC into their business model. So who knows? We'll see what happens. So why don't we get into the and when Jen, I get to you, you can chime in on the hemp thing as well. One thing I tell, and tell me if I'm wrong in this, I often tell people this whole messy path to legalization that maybe started 25 years ago in California with medical, and then Colorado jumped in with rec. And we've got different paths to legalizations. And so the path we've really seen was the state side on cannabis anyway for many years. We almost got the MORE Act passed a couple times. So that's another method Congress can legalize. We got close and failed. Another way is rescheduling. The HHS and FDA, we got close there, and everyone was so hopeful for that this year. It looks like who knows? Trump never ceases to surprise us, so maybe that's still an option. And then we've got even the courts, possibly with like this New Mexico case and/or the Supreme Court. So we've got all these different methods to legalization. or restriction. But Jen, why don't I turn it over to you and we can dive into the New Mexico case, or you can also backtrack anything else on the hemp side, but I think we'll be.
No, I think Rachel covered that really well, and I would say, carries the water in our group on that issue. I've been very focused on the New Mexico case with Rachel and with our team. It's a case where the taxpayer was audited and they had a disallowance as a result of the audit. The disallowance actually covered cost of goods sold, but they've got that issue worked out. But when they filed a tax court petition, even though they applied 280E on their tax return, they claimed that it didn't apply and raised three arguments. One is that based on the HHS recommendation, marijuana no longer falls within the meaning of Schedule 1 or 2, which is the specific language in 280E. 280E doesn't refer to what's on the list. It refers to what's in the meaning of, which we think tips you over to thinking about what the actual factors are and being able to rely on the HHS determination to say this is no longer within the meaning of. There's a second argument that would be applicable to only medical companies, and that is an argument that because Congress has defunded DOJ prosecuting medical marijuana companies, this is no longer prohibited by federal law. And that's another little magic language in 280E that could be used to make more of a textualist argument about why 280E doesn't apply. And then there's a Commerce Clause argument that piggybacks on Canna Provisions case. And so that one is in there because we've still got Canna Provisions going along. And if it is successful, there could be another argument to say 280E doesn't apply. So I think this case is, potentially good news for the industry. Because this litigation is different from other litigations, which have challenged 280 on constitutional grounds. Those were always really hard cases to win. This is more of a textualist argument. And when we've had a shift to more conservative judges, they like textualist arguments. So we think it's, timed well and a good argument.
Can I ask, so, and this came up, and because I was thinking the same thing, we had all these cases from Champs through Harborside and went on for years and years. And one thing that was actually a new thing was that HHS study that Biden had done that took a year and a half. And then they formally said the federal government, not only the federal government, that's where all our doctors and scientists live in the federal government. They said this is medicine for good reason. It's medicine. We say it belongs on Schedule 3. And then just for good measure, FDA came in and said, we're other scientists in the government. Yeah, we agree. And so the DEA, that is not our scientists, those are our policemen. They haven't agreed yet. But it's like, is that the new information that that to me seems a really good thing for the case that Harborside might not have had, that, hey, our own federal government said this is medicine. Schedule 1 says you can't be medicine and be on Schedule 1.
Right.
So
well, and that is the position of the petitioner's case. It involves tax years 2018, 17, 18, 19, something like that. And they are focusing on how that changes how we interpret 280E. We're working with some industry groups to elaborate on this point, because actually when you look at the history of the CSA and the language of the CSA, HHS's findings are binding under the CSA rules. And all along from the beginning, there has been acknowledged by various parties, ALJs, scientists, that there is a medical use and that it's not a highly addictive subject. And why that matters is because of also another legal change that we've had, which is a shift from Chevron deference, which is where the courts are going to defer to the agency's findings, even if they're arbitrary and capricious, because they're the experts, to the new regime that we have where Chevron deference has been overturned, and we now have this Loper-Bright standard where the courts are supposed to look at the statute and come up with the best reading of the statute. So all those prior findings can be looked at under this new light to maybe drive home this argument a little more.
So a couple of things. One, this sounds like to me that this is the biggest bright light I mean, because we've had a lot the last couple of years in particular, things have been kind of a struggle. Like this is really a bright light because in just from the financial side, if 280E goes away, just forward only or forward and backwards, absolute massive cash flow boom for the entire industry. We're going to see capital flooding in. It's going to be just a massive windfall. So one, I love the good news piece. I love the idea that hey, they said yes, this is medicine. I think the best argument on if anyone who doesn't agree it's medicine, I say the most easy medical use case for cannabis is you've got cancer, you can't eat, you're hungry, and we all know cannabis gives you the munchies. Like anyone in the U.S. would disagree with that. So that's our very first and good use case. So let me ask you.
I want to add a little caveat on top of all this, which is the IRS does not agree with this position. They're litigating it. No court has ruled that this is correct. So people need to talk to their tax advisors, think about the best way to proceed. We're certainly not saying you can ignore 280E, but we're saying this case could change how it applies.
Well, so two questions on that, because I know the courts move really slowly. I heard the IRS till January to respond. Is this something that could possibly get a final answer, or is it got to work its way to the Supreme Court and maybe 2 more years?
Yeah, I mean, it's hopeful that we could get a tax court decision next year, but the tax court, once this case is fully submitted, which would be in February, the tax court has as long as it wants to rule. And because these are new arguments, what's likely to happen is the whole court is going to take a look at this and issue what they call a full TC opinion. So we do think it's not going to be a swift process. And it is anticipated that no matter which side loses, there will be an appeal, and that would be to the 10th Circuit. So there could be a moment where things shift if the taxpayer is successful in tax court. So people just need to keep on top of this topic and be sure they know what's happening. And who knows what's going to happen in the meantime. I mean, we've talked a little bit about what's the timeline for rescheduling. Rescheduling helps us with 280E going forward. This could possibly help, this case could possibly help going backward, but I know some people who are very bullish on rescheduling is going to happen in the next, 6-9 months.
Yeah, no, I think that's a great point. And so I always tell people too, because I almost always get, oh, this means 280 doesn't apply. I'm just not going to pay my tax. So I caution them on that. I've been kind of bullish on the rescheduling as well, just because, Trump himself said in pre-election that on Lex Friedman's podcast, I heard him said, hey, I think cannabis is medicine. And I think where it is right now, like I literally think Trump could tell Bondi to sign the damn thing. Like it didn't take a whole court process or years. And so if Trump gets in his head one day that, hey, I want to do this, it could happen quickly. And it is a lot of votes. It maybe went down the popularity this year, but it's still a vast majority of Americans. So that would be positive side as well. And then you just said the going backwards, which would be, gosh, what a windfall if we could go backwards as well. So maybe we'll have so that's good news, and I'll tell people to caution too, and maybe I'll turn it over to you, Rachel. Bring in maybe the canna provisions as well. Is that any news? And then I think from there we'll transition into what can we do around 280? What should we maybe not do? Is there any update on what Trulieve did and just said, give me a refund, and the government actually did give him a refund? So maybe we could hit 280 next, but anything else on the court side that is good news going next year?
So one of the cases that's been newsworthy, at least in the cannabis industry, is this canna provisions case, which actually has moved pretty quickly. relatively speaking, through the courts. It's on October 24th, attorneys in that case filed a petition for writ of certiorari. Sorry, that's a hard word to say. To the Supreme Court, urging essentially a revisiting of Gonzalez v. Rake. And so basically arguing that Rake wrongly applied a rational basis test to determine when Congress can regulate purely local economic activity that traditionally falls under police powers. So they're sort of making a few different arguments about why Rake should be revisited and potentially overturned, including that there's changed circumstances, meaning that the premises underlying Rake are no longer true, that modern regulated marijuana is very different than the marijuana back in 2005, which was purely for personal use under Rake, that there's reduced interstate commerce. It reduced interstate commerce of cannabis. The legalization of cannabis has reduced interstate commerce, and that state regulated programs have actually decreased rather than increased marijuana trafficking. And they're also saying that there's been this sort of federal policy shift, which is very similar to what's being said in the New Mexico Top Organics case, that Congress has prohibited DOJ enforcement against state medical marijuana programs since 2014 and ceased sort of prosecuting state compliant cannabis businesses. And then there's also some federalism concerns, that this is an unprecedented federal intrusion into states' police powers, that these states have chosen to regulate marijuana, and that's not right either. So we've got this case. We don't know whether the Supreme Court is going to grant cert on this case. If they don't, then I guess that's the end. But if they do, it'd be really interesting to see sort of how the court views this case. The lower courts have essentially deferred and said, look, this is precedent. We can't really overturn precedent. So they did want to get to the Supreme Court, is my understanding, relatively quickly, and they have, because this case has moved quickly over the last, I think, year and a half or 2 years.
So when would it be heard at the Supreme Court? And an answer, is that something next year?
So it has to be chosen to be heard. The Supreme Court has to agree to hear the case. And that's what the petition is for. I don't know when they make that determination. Actually, Jen, do you have any idea when they?
I don't think there's any timeline under which they have to make that determination. They make those determinations on a regular basis, for sure.
Yeah.
Now, one, I guess, good thing, if and when the Supreme Court acts and makes a decision, especially if it's good, I mean, that's kind of a done deal. Once you're through that process, there's no more, it's whatever they say goes kind of deal. Doesn't matter what
it's supposed to be the law of the land, but we have seen we're in unprecedented times when it comes to the rule of law. But yes, I mean, that's assuming they agree to hear the case and then make a decision on it. Then that would be the law of the land.
So that's and we've seen this as we get into 280E. It's kind of a ping pong match every election going back to 2014. It goes back and forth, and whoever takes power at the main election with the president, the midterms go the other way, and then we get more gridlock and nothing gets done, and then it becomes an issue of voting. So but we've always got that hope, because I mean, like that MORE Act, it got reasonably close to passing. So there's nothing to say that can't happen again. I don't think it happened under this president, but maybe the next one. On what if we flip back to Jen and 280E, and I know this has been our endless topic at AICPA, and just it still applies, obviously. What can people do? What should they maybe not do? What's extra risky? Yeah. And we can also look at protective refund claims too versus.
Well, that's where I was going to start. I think that's the easiest no harm path. And that's when you file a document with the government that says this case may change the outcome and I may be entitled to a refund. There's lots of things to think about before you do that, but that option is out there, and it's limited to circumstances like this where there's a case that could change your taxation in a prior year. And that needs to be watched for years where the statute of limitations might expire soon. So that's something that doesn't have a lot of downside for most people. I think that otherwise, until we get some guidance from the IRS or this court, there's really people need to rely on their tax advisors in how to file returns and whether to amend prior returns and figure out how to do that, because there's a penalty exposure for seeking an erroneous refund. So it has to be done wisely. And the IRS's position is any refund claim based on 280E not applying is invalid, and also is targeting people who are trying to protect themselves from penalties. So there are a lot of things to think about, and it's not that hard to find out who you need to work with to
Now
figure out your situation.
So say you just do file a refund claim, kind of like TrueLeaf did, and you get money back. You're saying if it's overturned later, you could be risking lots of penalties and interest, because right now 280 does still apply. Is there any more news out of that TrueLeaf thing? Did they get to keep the? There's a lot of.
I haven't seen anything. The IRS has a couple years to come back and get that money back from you. So it's very possible that they're dealing with the IRS and IRS audit. It's very possible that they may have to pay that money back. It's very possible that the IRS is saying, you need to pay it back, and you need to pay us a 20% penalty and interest. So those are all possibilities.
Okay, so that's good to know on the 280E side. One other question we had in our group, this was actually in New Mexico too. So like, well, we set up as a nonprofit, so 280E doesn't apply. I don't think that's true, is it?
No.
So Rachel?
That's not true. The IRS doesn't recognize the nonprofit status of businesses that sell cannabis.
So you just still file.
And so that's why, there's been a number of states that have actually, when they develop their marijuana laws and regulations, they determined that, medical marijuana businesses could only be nonprofits. They've sort of gone away from that.
But that's a nonprofit for corporate law purposes, right?
Right, nonprofit for
which doesn't mean you're automatically a nonprofit for federal income tax purposes.
Which is where I was going.
Okay.
So yes, the IRS, you'd still have to file a regular tax return. You're not going to be able to file a nonprofit tax return if you're a cannabis business. So they don't recognize the nonprofit status. So in the eyes of the IRS, cannabis businesses are for-profit entities and are subject to 280E.
And I've been saying the broken record for years of the whole, any kind of entity games, 280E doesn't apply to entities, it applies to trade or business, and the word trade or business is as broad as you could ever have. And so I say you could have no business. It could be your teenager selling weed out of the basement, supposed to file a tax return and subject to 280E. So
yeah, just remember Patients Mutual was a nonprofit, Champ was a nonprofit business. Those were all nonprofit businesses, but obviously the IRS didn't consider them.
So that's not good. And so I'm going to keep pitching. Yeah, 280 still applies. Let's be conservative. Let's do the protective refund claim for as many years as go back if it applies. And I think this New Mexico case in particular seems a reasonable basis. Do the on the what was the other thing on the other 280E? Oh, 471C. Is that still, there was always so many negative things to me outside of tax to doing 471C, but I thought the IRS responded that that's not really, people like, oh, just go on cash basis and you can deduct everything kind of deal.
What I could tell you is the IRS does not agree that you can put everything under the sun into COGS pursuant to 471C. They would likely disagree with that, but that's not to say that 471C isn't a thing. It's just that's, whether or not that means you can put certain things in COGS. I think that's potentially an area of contention or disagreement. They may challenge things that you put into your COGS if you're examined, even if you file saying you're
cash
hitting 471C. So that's
well, and it's limited to taxpayers with gross receipts under a certain level. So it's not an option that's available to everyone. And I think when people talk about it, they usually fail to mention that part. So I always like to bring it up.
Well,
Well,
I
and
also I also want to mention too that like all of this, whether you're entitled to file or whether you should or shouldn't file an amended return to claim a refund or lower your tax liability, all of these things are dependent on facts and circumstances. There is not a one size fits all approach for any of this. You have to look at
now,
for your business operations, what do you do, what type of licenses do you have, how do you operate? All of these things should be looked at closely. So, to sort of blanketly say that everybody can do X, Y, or Z, I just don't think that that's quite
now,
accurate. You really
Well,
should
and
be talking.
to bring up a story, I've had clients come to me who didn't apply 280E. They're like, we got to file refund claims. I'm like, no, you don't. You didn't apply 280E. So, like, wait for the statute to run. That's your best path. But people get caught up in all the lore and, somebody got a refund and that you always have to go back and sit down and look at the tax returns, talk about how they were prepared, look at when taxes were paid, think it through. What is your timeline? What is your exposure? This is not all upside for everyone.
now, by the way, another recommendation I'm making, you brought up a good point. It's like telling the police officer, I was going 90, but everyone else was going 92. It
Right.
doesn't get me out of it. It just because,
Yeah.
and it's amazing that people use that argument like, oh, I know a friend who got a refund, so I get a refund.
Yeah.
So one thing I do tell when people start even debating me in my group, I'm like, look, or a client is really pushing back and they're like, I'm doing this. I'm like, look, that's great. If they've got a $20 million company and they're going to file some refunds or whatever, I bring you two up. I was like, you should go call Rachel and Jen at Holland Hart. And if you're really going to do that, or your client really wants to do that, bring in the expert tax attorneys that are trying these cases and get that better advice. Because most of us are just the CFOs. We know enough about tax to be a little bit dangerous, but I think again it just makes sense. If you're going to take some kind of $1 million position, you might as well spend a little bit of money on the attorneys, and then you can. And also, I know you all have that knowledge, kind of insider knowledge to what's going on in the courts, and you're actually talking to those IRS auditors. That may be my final questions because I've had.
Well, I would just want to add to
Oh
that,
yeah,
that like any business decision, it's a risk versus reward analysis,
Mhm.
right? You have to go into it with your eyes wide open. So you want to understand what are the risks versus the rewards. And a lot of folks don't understand that, you know, you may not be looking at big dollars here by filing an amended return, but there could be a lot of risk, in your future
oh,
because you file that. But so you have to kind of look at all of those things before you determine to take those paths.
and we've also talked about in the past that putting the target on your back. Do you really want the IRS to show up? And I don't, but some people don't care.
Well, people don't realize that, future examinations and having to hire an attorney like Jen or I, we're not cheap.
Yeah,
So, so this is all costs that you could potentially have to, undergo
and
if you end up, filing a refund claim. So you
so
have to
for
think
an
about all of that.
example, that New Mexico case, I'm guessing someone's paying for all these legal fees that could go on for years. So they've got to have deep. I know Harborside, gosh, they paid a ton as well. So last question on maybe the IRS, because I get this one too. Well, they just fired half the IRS. I got no worries. They're not going to show up here. They're understaffed, and but I was like, if they're doing something this year, it's probably the IRS like 4 years from now. Maybe they're staffed
Mhm.
back up by the time they come to look at you. So, any thoughts on that? Like, is that making your all's life easier that there's fewer IRS people or
I
not?
think we still have a laser focus on the cannabis industry. I
They,
don't think that has changed at all. And I think they're well aware sort of this refund claim issue.
Well, and I would say that because they've become more targeted in how they approach exams, they pick a lot of issue that involves a lot of taxpayers and they go all in. So it's not like you're going to come out of this exam with a no change. You are not, because
Yeah.
they're targeting you because they have a legal position that's the basis for it. So other exams sometimes have a different angle, but this type of exam is not one where you're going to get out squeaky clean.
Well, this has been incredibly informative. As always, we don't know the final answers, but maybe final question for both of you going into 2026 election year. Do y'all want to make any predictions? It's end of the year and say, my personal prediction, I'm going to be optimistic. I'll say my prediction. Next year's going to be better somewhat, somehow. We're going to get more legalization, more Florida's going to win their vote or rescheduling, or we'll see. But either of you want to make a prediction on any of this stuff?
I would just like to say that I am also eternally optimistic. I mean, I always go back to cannabis is a plant that nature created.
Totally agree.
And it comes with significantly less social harms than other legal drugs like alcohol and tobacco. I know this fight is always one step forward, five steps back, but I think we have to continue to educate our lawmakers about the realities of cannabis and dispel the myths. I think we've got to continue to do that. That's the path forward. But I am going to be optimistic that someday in my lifetime, cannabis will not be a Schedule 1 or Schedule 2 controlled substance.
I'm not going to make any predictions, but I do think this education point is a really important one. And we're focused on making sure the tax court is educated on this history and the information. And I hope that telling that story is persuasive in this setting.
Well, awesome. And by the way, I'll make my final prediction. You are involved in the New Mexico case. It's going to win for the industry. And it's going to be because of all the fantastic work you're doing behind the scenes. So tell people where they can find, definitely sign up for your all's newsletter. You mentioned an amicus brief you're working on. That I'm guessing you'll put in your newsletter as well. And then we'll also put your emails and website and all that as well.
So I'll just
Perfect.
mention the newsletter and Jen can talk about the brief briefly. We have this great newsletter that we put out every month. It just covers sort of the latest updates in cannabis policy. We usually cover what's happening in tax court related to cannabis related cases, other litigation, hemp. It's called The Buzz, and you can sign up for it on our website at hollandandhart.com. So please, it's actually Holland Hart, I think, is our website.
Yeah, I was gonna
hand.
mention that.
So there's a way to, if you look up the cannabis group, you could probably find a past publication and find out how to sign up. But it's a great newsletter. It's very informative. So I just wanted to mention that.
And I'll put a link there. And also you all are both very easy to find on the website too.
Yeah. So the amicus brief, time is of the essence. We got an extension until December 1st to file this amicus brief. So
Wow.
if there's anyone who's interested or industry groups that want to come forward and be part of that, we're happy to talk to everyone. We are putting together, with the help of Colorado Leads, a fundraising pool to fund that matter. And we're going to have the link for that shortly. So reach out to us. We will fill you in.
Awesome. I'll spread that news around as well. Well, thank you all for being with us today. And as always, and maybe we can do a regroup in springtime and see if there's any movement on any of this stuff, and we'll be hopeful from there. But yeah, thank you for joining us, and we'll post all this stuff where everyone can find you easily.
Thank you, Andrew.
Thanks for having us.